Hello, my name is Joseph M. Jason. I'm a member of the National Alliance on Mental Illness. I'm here to give an update on my incarcerated son, Daniel S. Jason. My son, Daniel Jason, has been in jail and prison in Iowa since March of 2007. In May of 2008, he was sentenced to 7 years in prison for stalking his ex-girlfriend and tampering with a witness. Daniel has Asperger's syndrome and severe mental illness. Daniel's crimes were nonviolent. Most of his crimes were sending emails in violation of an order of protection. Despite concerns raised on Daniel's mental status by his parents, Daniel was allowed to represent himself in the court proceeding. Daniel was in jail for 14 months before the trial and did not receive any mental health care treatment. There was an appeal of the court determination, and the decision was released on December 17, 2009. The Court of Appeals determined there should be a hearing to determine if the court should have prevented Daniel from representing himself. Prior to sentencing, my wife and I were instrumental in making sure there was a psychiatric evaluation. There was an attempt to have it before the trial, but Judge Hibbs would not allow a continuance. The application was finally granted, and Daniel was evaluated by Lauren A. Elson, a highly respected and board-certified psychiatrist. The evaluation confirmed the diagnosis that Daniel suffered from Asperger's syndrome. Dr. Olson also opined that Daniel's brain disorder causes an inability to estimate cognitive, perceptual, and affective responses in the lives of others as well as self. Dr. Olson recommended treatment instead of incarceration and in order to medicate involuntarily if necessary. Prosecutor Minute at the sentencing hearing ridiculed the report and displayed her ignorance of mental illness and Asperger's syndrome and her lack of compassion for organic brain disorders. I wrote after the sentencing the following: the prosecutor, Deborah Minute, decided based upon her non-existent psychiatric expertise that Daniel could control his behavior, which includes psychosis and obsessive-compulsive disorder. This was despite a preponderance of evidence to the contrary, including a report from a psychiatrist, Dr. Olson. She said that Dr. Olson had the longest report she'd ever seen, and he had taken great pains to diagnose, but then he was grasping at straws. Prosecutor Minute openly chastised me at the sentencing for advocating for my son by filing motions for the court and including material that should be read by the judge as well as herself. This included many articles on Asperger's syndrome and a position paper that I prepared. There was no autism expert present in the courtroom. Daniel has been, in 2009, he was in partial hospitalization in the Iowa Medical and Classification Center in Oakdale, Iowa. Sometime before December 8, 2009, Daniel was committed. The court did find, and this is very rare in Iowa, the court did find that Daniel was disabled to the point that he could not make effective decisions about his mental health care. Dr. Cellini, the mental health director of the Iowa Department of Corrections, recently wrote to me in an email, "I realize you and your wife have been concerned about how he has been doing here, and since the commitment he has been taking medication on his own daily, and he has done very well. I can point out for you that even though he thought the medication might be helping before the commitment when he took it sporadically, he chose to refuse to take it long-term until he was committed. He has not been having the symptoms he had before at all, and as a result, he has not had reports within the system. He has made no threats, and the issues of self-harm that existed before have abated. He is on a low dose of olanzapine at 2.5 milligrams a day. The literature supports this type of treatment, and your son has responded very well to it. Should he need additional medications or changes, we can keep you informed as he does have a release signed to share information with you." On December 15, 2009, the federal courts indicted Daniel for making one threatening communication to an attorney that he had never met. Daniel had been making threats to get attention in his mental state. The attorney who was threatened by Daniel was warned of this via email, but she chose to contact the FBI later on. The Justice Department waited a year to indict Daniel. The indictment is a grave injustice and may be a violation of constitutional rights. The prosecutor has admitted that she did not know Daniel was committed when he was indicted. The Department of Justice is seeking to give Daniel another 5 years in prison. As of yesterday, March 11, 2010, the federal government still wants to prosecute Daniel despite the fact that they agreed to move him back to Oakdale in Iowa in December. Daniel's trial commences on April 12, 2010. I've provided various documentation to the federal prosecution and talked via phone to Dr. Bruce Cellini, the prosecutor had talked to Dr. Bruce Cellini, who gave powerful persuasive testimony, as I understand. As again, he is the mental health director of the Iowa Department of Corrections, I have also provided the prosecutor treatment options for Daniel when he gets out of prison. One has to believe this injustice is not what Senator Durbin has in mind when he chaired the Senate Judiciary Subcommittee on Human Rights and the Law and held a hearing on human rights at home, mental illness in the United States prisons and jails on September 15, 2009. Mental illness has been criminalized in our country over the last 30 years, Durbin said, by allowing our prisons and jails to become a primary provider of mental health services. We have taken a step backward in the effort to protect the human rights of people with mental illnesses. Thank you very much.